Today's video is brought to us by the generosity of Firearms Legal Protection. Firearms Legal Protection is a legal defense program for lawful gun owners. You win the fight, and they will help you win the fight after the fight for the rest of your life. There's a link in the description for a coupon code for a discount for all active self-protection watchers. So now the trial, as we go through, we're making arguments both ways. I'm going to be taking anywhere from 2 to 3 days that I'm going to be in court to months.
Think of it like this. We're not actually making arguments. What's happening is because the state has the burden, the government or the state, depending on your jurisdiction. If it's federal, it's the government, and here it's the state. It could be the people in other places. They have the burden of proof, so they get to go first, right? Going first is an important issue, but they get to present all of their witnesses. So state's witness number one goes up there, direct examination, then cross-examination, then a redirect examination, then witness number two, same process, 3, 4, as many witnesses as they get to call, all of their witnesses. Now, there might be some of those witnesses who could also be defense witnesses. You have an option. You could cross-examine their witness as part of the state's case, or you could pass and then recall them as one of the defense witnesses. So after the state finishes presenting all of their witnesses and all of their evidence, and you'll know that because the judge will say to the prosecutor, call your next witness, and the prosecutor will say, the state rests. What that means is I'm done. We've presented everything we got. Well, at that moment, there's usually a recess of the jury. The judge will say, okay, well, this is a good time to take the mid-morning break or something like that, and they shuffle the jury out. And the reason they do that is because they know that almost always there's a motion coming from the defense. The concept of the motion is as follows. Hey, judge, they just presented everything they got. No reasonable jury could convict my guy on that evidence. And the concept here is sound because what you're really saying is, we shouldn't have to take a chance of filling in the gaps by presenting our own evidence. What if my guy gets up on the stand and says something that he shouldn't have said and then now fills in that gap? At this moment, there should be enough evidence that a reasonable jury could come back and say guilty. If there's not enough evidence at this point, either because the evidence is too weak or because some element there was no evidence presented on some element or something, and that can happen. Sometimes we have a little bit of a feud going on in Arizona right now on this issue of whether a firearm, which in order to be a firearm, it has to be operable, or at least not permanently inoperable. Whether we have to allege that as a defense or whether they have to prove it as one of the elements of the crime is not settled yet in Arizona. So we might stand up and say, hey, judge, they didn't prove it was an operable firearm. They might say, well, they didn't raise it as a defense. They can show in their defense case that it wasn't.
It's not my job.
Well, this is unsettled still in Arizona. So the judge will then rule on that. If the judge rules for the defense, the judge is taking that's a big statement, throwing the case out.
Yeah, you're done. We're out of here.
Case is over.
Yeah.
That's the end of that. We actually have won several of these. We have a little bit of a streak going on. The last several misdemeanor trials we've done, Andy Marcantel and I have gotten what we call a Rule 20, because that's the rule that allows for what I'm talking about here in the state court. We've won, I think, 3 of them now in a row on Rule 20, which is really embarrassing for the prosecutor.
Yeah, no kidding.
So normally the judge will deny that, and then you move to the defense case. So then the defense will call its first witness, if they have any. The defense doesn't have to do anything. The defense can just say, we rest. They don't have to present a thing, and you move right to closing arguments, right? Because we don't have the burden of proof.
Right.
So we could simply say, we rest, let's argue the case to the jury. They didn't present enough. If we want to present evidence, that's the time. So we start calling our witnesses, same deal, direct examination from the defense, cross from the state, redirect again from the defense. It's very rare to get recrossed, but it can happen sometimes under certain circumstances. And then that goes through, and then that gets finished. Eventually you hear defense rests. And now we're settling jury instructions and we're moving to closing arguments, which is my very personal favorite part of the trial because we get to argue. That's the first part we get to argue.
Now we actually have to.
Yeah, this is the fun part. This is, I always find myself pacing right before because I'm just so excited. I'm waiting for this prosecutor to just shut up so I can get out there and tell him how it is. So It's super fun part of the case for us because we get to go through all of the evidence now, go through all of the witnesses, talk about the exhibits. We can pull things up and talk. We can make analogies. It's all argument. It's all fun. In fact, one of my really favorite closing arguments in the Elizabeth Johnson case was up on the website. You can see it. And
got to watch that and see Mark do his thing.
I had a lot of fun. It was, in fact, if you watch the part where I talk about the founding fathers, how they didn't trust anybody in the system, they didn't even trust the judge. When I said that, the judge kind of rolled his eyes. I think you can see it on the video. But they didn't trust the judge.
No?
They trusted the jury.
That's right.
That's just the truth.
Jury is the finder of fact.
Just the truth. And we're think about that for a moment, to bring it back to some of our earlier, that's the reason we need the jury.
Yeah.
Because we don't agree on the facts.
Right.
If we agreed on the facts, we wouldn't need a finder
Easy
of
thing.
facts. The judge would just apply the law.
Right.
In a civil matter, that's what we call a summary judgment. We agree on all the facts. Hey, judges, tell us what the law is.
Right.
So it's almost always the facts. And if there was anything I would want your listeners or watchers, as the case may be, to know about this, they really got to be careful to keep in their minds it's not about what happened, just about what happened. It's also what people are going to say happened.
Right.
It's a fight about the facts, right? The most common place this comes up is, say you were dumb enough, as you mentioned in one of your videos, to go to a bar late at night with your gun.
Following the rules of stupid, right? Yeah.
Following the rules of stupid. And now there are 5 drunk idiots who come out and are threatening to beat your head in because they didn't like something about your shirt or something. And you pull out your gun and say, hey man, leave me alone. Maybe it's a valid defensive display of a firearm in Arizona. You pointed it up or down and you backed away and said, leave me alone, I don't want any trouble. Well, if those 5 guys say what you did was you pointed it in their face,
right,
and said, I'm going to blow your brains out, you whatever, well, you got 5 people saying that. You got to deal with that now. Even though it's not really what happened,
right,
it's part of the risk in the case. You always got to think about, it's one thing if you get it on video, then it always questions what happened before the video or after the video, or maybe you didn't catch everything. But if it's well documented, that's one thing. But most of these are not well documented.
Right. So now the jury gets to take whatever time they need to decide after they're instructed.
Jury gets the jury instructions, which is always a big fight as well, because we want the instructions that more accurately go to our legal theory, or maybe some instructions seem a little too tight. We had a big fight years ago in Arizona here on what should the instruction be for reasonable doubt. What does reasonable doubt mean? Now we have a standard reasonable doubt instruction, but you can still always make the argument, hey, for this case, we need to tweak it a little bit for some other reason. So we have big fights on the jury instructions.
Okay.
We get into discussions about whether a lesser included instruction should be submitted. So in other words, if you don't find guilt on this, you can then move to guilt on this. Why would we want that? Because, you might get into a situation where jurors don't do what they're supposed to do. They sit there and say, well, the state didn't really prove every element, but I just don't want to let them off. So what do? That's sometimes where a compromise can come in. They may say, okay, fine, I'll go with the lesser included offense or something like that.
Right.
So we get into big fights about jury instructions, and then it's a waiting game. They go out, they get sequestered, they're deliberating, and they can be out any length of time. Normally what will happen is, especially if it's a big trial, it's going to take a while. There's a lot of evidence. I'll go back to my office. We get to leave the courtroom, and the judge will say, make sure you're, 40 minutes or whatever you are. And then usually the judicial assistant will call and say, either they're done for the day, we're going to release them, or they got a verdict, or because Arizona is very forward-thinking, we've sort of debuted a new possibility here, which is the jury has a question, which I really like.
I love it.
Yeah. Jurors actually, and I didn't talk about this as we were going through, but jurors actually get to ask questions of witnesses in the state court now. So just before the witness is excused, the judge will say to the jury, does anyone on the jury have a question? And the jurors will write down questions, pass them down, and then we'll go up and we'll meet with the judge. And the judge will quietly it'll be on the record, but not in the presence of the jury so they can hear. We'll read the question. It could go to something that was already been excluded, right? So we'll say, judge, they can't talk about it.
Right.
Or there's a hearsay objection, or there's some problem, or let's change it around a little bit, we'll ask it differently. And then if we can, we'll ask the question, the witness will get to answer, each side will get a follow-up, and then we move on.
Huh.
So also in deliberations, we can get questions, and often do. So the lawyers will get called back. There'll be a question from the jury. Sometimes we'll say, oh, we see what they're thinking about. We see they're thinking about this or that or whatever, and we'll try to craft an answer in a certain way. And then eventually you'll get the verdict, which is really, there's no win-win or compromise here. It's going to be thumbs up or thumbs down.
Right. And I mean, at this point, I've been out of work for a number of days. Could be a few days for the trial, could be months. This could have, a disastrous impact, obviously, on my profession. It's going to be, if it's a big, high-profile case, it's going to be in the paper. It's going to be all that stuff. So, I mean, to this point, okay, so guilty or not guilty, we've pretty much hit the limit here. Do you have a feel, Mark, for how much this costs the average person who wasn't prepared for it in advance?
It really depends on so many factors. And this is why at my firm, we don't have set rates on anything. I want people, we charge them $100 to come in for what we call a strategy session, because people sometimes will call up on the phone and say, how much do you guys charge for a DUI? It might sound like an easy answer, but it's not, because there are many different factors, and we just don't practice like that. So we charge them $100 to come in. We spend about an hour to an hour and a half with them. We go through everything so they understand a huge amount about the system, what they're looking at, possible defenses, and we get educated about what we're looking at. Because really what putting you in the mind of a defense attorney, we sell one thing at our store, time. That's all we sell. So if you got a DUI case and there's no stop issues, there's no suppression issues, the blood and breath is all set, you've made a confession, you drove into a tree, all these things. Sometimes on those cases we'll say, better off to not even use a lawyer. I mean, you can hire us.
Just go plead guilty.
I like to explain it as, if you want to hire us to play for a fumble, we will. And I have had cases where there have been fumbles and we've recovered and things have gone well. But people should know, they should go into it with their eyes open. If you're going to lose, and I always look at it with two analysis. Number one, are you going to lose? And then number two, if you do lose, are you going to get the bare minimum? So there's nothing we can really do for you. If you're in that box, I say you don't need a lawyer. Don't hire a lawyer. Save the money and go do this, and get it resolved. But in the strategy session, we get so much information that now I know how much time you want to buy. So I can give a flat fee estimate, or we can always do hourly. And then depending on the nature of the case, I adjust things. Sometimes I'll get a case that'll, for lack of a better way of saying it, will piss me the heck off. And I'm going to represent this guy, and I don't care. Sometimes we say we take it for the freedom of it. I almost never will take it for free, because I want people to have some skin in the game.
Of course.
But we've had many cases like that where I got a point and I want to make it, and I'm taking this case and I don't care. And then there are other people who, oh my God, this client's going to be a pain in the neck. Not so excited about the case, not so excited about it, whatever. There have been times where I've said to clients, I'm not even interested in taking your case.
Well,
I remember a dad one time didn't like that answer. He said, I'll pay your full rate. Tell me what it is. I can pay it in full. And I said, I'm not interested. I think I'm going to pass on this one. I didn't like the people.
Right. But I mean, so I guess the question still stands, though. I mean, typically, if it's going to go all the way through... Expensive. All the way through trial, probably costs more than your house.
It could, depending on the case.
Depending on your house, too.
Yeah, if you go all the way through trial on a felony, I'm thinking low end, you're probably not going to get out of there less than 40 or 50 grand on the very, very low end. And on the high end, the sky's the limit.
So, guys, I think that the lesson at the end of the day, I want you to know this stuff going in, so then that way, God forbid you have to press the trigger, you know what's coming. You have some understanding, so you're not just sitting there anxious, wondering what's to come. But also, I think again and again and again, the lesson is stay out of these if you possibly can, because the process is punishment, even if you don't get found guilty of a criminal act. And then, of course, we have the whole civil side that we're going to have to go through as well. So it's a second opportunity to let the system punish you. But that's for a whole nother day. Mark, I mean, this kind of information is invaluable. It makes me even more cautious as a self-defender. And, at the end of the day, the only time, in my opinion, that you would press the trigger is if your life is at risk. Because otherwise, you hear people say, I'd rather be tried by 12 than carried by 6. I don't know that you want to be tried by 12 in any capacity whatsoever, because this sounds like it's just an utter terrible punishment, but death is worse.
best to avoid the whole situation.
Right. So if I go, no, he's going to kill me if I don't shoot him. So I'll shoot him and then deal with the aftermath. Like, I mean, that's the choice, right? But if I can possibly avoid it, it's best avoided.
You know, it is fair to say, I've had people, we had 2 of them recently who shot and killed other people, didn't get charged.
Right.
Doesn't mean you're always going to get charged.
No, I mean, if it's, right and right and right, and the district attorney sees it as right and right and right,
Yeah.
okay, but...
Do the right thing is a good rule for life.
Right.
Figuring
there it
out
is.
what the right thing requires a little bit more skill.
A lot more skill.
But at least if you're attempting to do the right thing, you're moving in the right direction.
And I mean, most folks that I talk to, and I get to talk to a fair number of people that have been in defensive gunfights on the Active Self Protection Extra channel, they end up not getting charged because, you do the right thing. It's clear you've done the right thing, especially in our case because they almost always have video evidence of them doing the right thing. Then the prosecuting attorney goes, nope, you're fine. We get a little document from the prosecutor. We've determined this is justified conduct and have a nice day or whatever. It's closed and you go from there. But, worst case scenario, if you live in San Francisco or you live in Austin or you live in Boston, these things can happen. So, Mark, really appreciate the knowledge.
Thanks for having me.